All right. Hopefully you can all see and hear me. Please let me know if that's an issue at any point. My name is Dana Voglitis. I am the Associate Director of the Office of Technology Development here at FAU. My office is responsible for the legal protection and commercialization of all of the intellectual property that's developed through FAU Research. So I'd like to thank you for attending our second webinar of the year today, titled Ask the Expert, How Do I Protect My Research? It will be a discussion about using patents, copyrights, trademarks to protect intellectual property that's developed through your research. Specifically today, we're going to focus mostly on patents because that is the area of intellectual property that arises most often in the context of university research. But if at any point you would like us to focus on copyrights or trademarks or answer any questions about those, we're happy to do so. Just a little disclaimer before we get started. This is an educational webinar. It should not be construed as legal advice. David and I are not your attorneys. If you have specific legal questions or need specific legal advice, we encourage you to consult your own attorney. Now I'd like to go ahead and introduce our speaker. David Tenner is a managing partner at the law firm of Caesar Rivas in Philadelphia, Pennsylvania, and they serve as outside legal counsel for my office for FAU Intellectual Property Matters. So David, thank you very much for being here today. Would you please tell us a little bit about your background and what your role is at Caesar Rivas?
Thank you, Dana. I appreciate you inviting me to this seminar. And yeah, so as you had mentioned, I'm the managing partner of Caesar Rivas in Philadelphia. We're a firm that's approaching 100 years old. I've been the managing partner for since 2012. The firm has approximately 12 attorneys, 12 intellectual property attorneys, and approximately 30 employees. My background is in chemistry. I have an undergraduate degree in chemistry and a master's degree in chemistry as well, both just in general chemistry, although my master's focused on biophysical chemistry to some extent. And since obtaining those degrees, I've been, and also, of course, a legal degree. I've, since that time, for the last 30 years, been involved and employed as a patent attorney, intellectual property attorney. So I have over 30 years of experience as an IP attorney.
Great. Thank you so much for telling us a little bit about yourself. I'd like to start very generally. I don't know the background of everyone that's going to be joining us this morning. So I want to start very basic and have you just kind of give our attendees an overview of intellectual property. What is it and why should a faculty member or student at a university consider protecting their intellectual property?
Well, intellectual property is property, typically intangible property, unlike real property, that is property of inventors, authors, artists, and other creative people. And I say the word people intentionally because an interesting area of the law right now is whether there are intellectual property rights in inventions and creations developed by artificial intelligence, and the trend is no. And there's also an interesting case that you may have seen in the popular media about a monkey who took its own picture. And the question was, is there a copyright? The questions were, is there a copyright and who owns the copyright? I believe the outcome was, there is a copyright. It's owned by the owner of the camera, not the monkey. So these things are still developing, but typically it's the property of the inventors, authors, artists, and other creative people. Sorry, was there another?
Yeah, so part two of that question was why is it important to protect your intellectual property? What benefits are there potentially for our faculty members and our students in doing so?
Sure. There's monetary gain, potentially monetary gain. There's public recognition, prestige, possibly. And in addition, there's potential freedom to operate. In other words, if you don't claim the rights, it's possible someone else may claim the rights. If your patent, for example, patent rights are the flip side of the coin with trade secrets. And if you decide to keep something secret and just continue to practice it without letting the public know through a patent, if somebody else independently develops it while you're trying to maintain it as a trade secret, they can develop a patent right and prevent you under certain circumstances from being able to practice the invention.
Right, absolutely. And trade secrets typically don't come up as much in the university context because most of you as researchers need to publish your research and let other people know what you're working on. So that's why patents typically are the vehicle that we see at universities for protecting your intellectual property. David, at a very high level, how would a researcher know, say, they're potentially interested in patenting, copywriting, et cetera, whatever it is that they're working on? How do they know if their innovation is even eligible for legal protection? What are sort of the first questions they need to ask themselves to make that determination?
Well, I mean, it's difficult for someone outside the field who's not an IP attorney to make the ultimate determination, but the screening of it, typically you want to look in whatever public database there is of the particular intellectual property you're dealing with to see if someone has rights to that. So, for example, patents, which is the main focus of this seminar, there are many databases to look through. So the USPTO, which is the U.S. Patent and Trademark Office, USPTO.gov has search pages. The European Patent Office and other places have more comprehensive search engines that enable you to look through published patents and patent published applications to see what looks similar to your application, what's similar to your invention. Now it's relatively easy to decide if you find something that's right on target, is exactly what you're doing, and the date of it is clearly before your conception of the invention. But when things become more difficult to determine, it's not quite like yours. There are modifications you can make that would make it different. You're not sure whether it's actually prior to your application because it's prior to your invention because the date is not clear to you when it was published. These are things that are best analyzed by an attorney, an intellectual property attorney.
Okay, so the take-home message is, take a look, see what's already out there in your field, what's already been done, utilizing some of the databases and resources that David described. But then you really want to contact someone with experience in this area. And for those of you at FAU, you would start with my office. So I'm going to move on to the next topic, which is disclosures, which is how you as the researcher indicate your interest in protecting your intellectual property to the university. So an invention disclosure is for potentially patentable intellectual property, and a works disclosure is for copyrighted material, both of those that David described previously. So in either case, you would fill out a disclosure form. It's available on my office's website. It's a very short form that describes the details of your innovation and the circumstances under which it was created. The more detailed the description, the better. If you have any supplemental abstracts, papers, presentations, posters, drawings, etc., those are always very helpful to include. We also want to know any sources of funding that were used to create your innovation, in particular federal funding, because there are certain laws that the university needs to abide by in that case. We also want to know if you have publicly disclosed your innovation to anyone outside of the university, and David will talk a little bit more about that later, why that could potentially impact your patent rights. And then we just want to know who was involved in the creation of the innovation. Who were the inventors or authors? Was this a joint effort? Did you create it by yourself? Did you work with people at other institutions? So these are all the details that we ask you to provide us in this disclosure form. And this is the first step in the process of obtaining legal protection for your research. So I've answered the first question on my list, which was how do researchers notify the university that they're interested in legal protection? The first step is completing this disclosure form. So David, from the outside counsel perspective, when my office sends you a disclosure form that a researcher has completed, what information are you looking for in order to accurately assess the innovation, make sure that a patent application is appropriate, and what information is needed to move on to that next step, which is drafting the patent application?
Right. So primarily, we're looking for a description of the invention. It would enable us to describe in an application how to practice the invention. We also want to know whether there is any prior art. In other words, are you aware of anything that somebody's done prior to you that's similar? That's relevant. We actually have a duty to disclose that to the patent office. We do file an application. We're looking for description of any of your activities, such as public disclosures, uses, sales, and offers for sale of the invention, because they could be relevant to whether you're capable or capable of obtaining a patent. The identification of the potential rights of others, including the federal government, and the identification of all the inventors or potential inventors. Those are the major categories of what we're looking for.
Okay, excellent. So that's all the important information you would need to include, and just kind of to emphasize one thing David alluded to is in the next step of the process, which is drafting and filing the patent application. What we want to be able to demonstrate to the patent office, or one of the things I should say, is that not only are you as the inventor in possession of the invention, you know how to make it and use it, but you also want to describe it in enough detail that would enable other people skilled in the art with your same credentials and expertise to be able to practice the invention as well. So just important to keep in mind the level at which you need to describe things. So I'm going to go ahead and move to our next topic, which is patent law at a very high level. So David, could you briefly describe for us what is a patent and what rights does it provide?
A patent is a grant from the government of the right to exclude others from practicing the invention for a limited period of time in exchange for a full disclosure of the invention by the inventors to the public. And this goes back to what Dana was just describing about what you need to disclose. It's almost like, in some ways, it's been described as like a contract with the government in exchange for you providing a full disclosure of what you're doing and the best way to do it in a way that people can practice it. The government will give you a monopoly for a certain period of time. And because of that definition, it also explains what happens if you don't comply with those requirements. It makes the contract, in a sense, void. And so if it's discovered later on that you're hiding details intentionally that are relevant, it could be that the patent, even if you've got it, is found invalid. So it needs to be a full disclosure of what the invention is to the patent office.
And what kinds of innovations can be patented? There are certain categories of patentable subject matter. Could you describe each of those for us?
Sure. Actually, the patent statute, which is 35 U.S. Code or USC 101, states that whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent, therefore, subject to the conditions and requirements of this title. So those are the major categories, but they define broader types of inventions that aren't within that literal scope of the claim. So, for example, a kit claim, it's potential. You could possibly get a patent on a kit, and so that word doesn't appear in the statute, but is patentable. So generally, technical developments. There was a time where less technical things were becoming patentable about 20 years ago, but over the last 10 years, the Supreme Court in particular has pushed back on that. So there's now an additional or more definite requirement of having some sort of technology involved to be able to get a patent ultimately.
And those four categories that you just mentioned, so just to describe them a little bit more, a machine is typically something that has moving parts. A process is typically something that is a series of steps to accomplish something. A manufacturer is typically an output of a machine, something that doesn't necessarily have any moving parts. And a composition of matter, could be some sort of chemical compound, something like that. David, did I describe all those accurately?
Yes, absolutely.
All right. And then in terms of meeting the statutory requirements to obtain patent protection, could you talk a little bit about those main conditions? And I'm alluding to novelty, non-obvious, and utility.
Okay, for this would be for a utility patent. So the utility patent is typically what people think of when they think of a patent. It protects the functionality or utility of invention. There are other types of patents we'll discuss later. But a utility patent has three basic requirements. First, a utility, and the utility relates to that part of the statute that I earlier quoted, and it's a very interesting area of the law right now because it used to really be very easy to show utility, and now it can sometimes be difficult. The second requirement is novelty. In other words, is the invention exactly like something someone has done before? And the way that usually plays out in the patent office is the patent examiner will do a search. Typically, it relates to patent publications, applications, which are patent publications, and non-patent literature. And if they find a single publication that describes everything you're doing, and most importantly, or even more critically, if they find an embodiment, a single example within there that's exactly within the scope of what you're doing, then your invention, as it is claimed, lacks novelty. Now, if the patent examiner fails to find a single reference, that doesn't stop the inquiry. They will then find additional references. So if that will fill in the deficiency. So if the primary reference is missing one element of what your invention is, they will try to find a second reference that supplies that secondary element. And if that's done, they will then make an argument that it would be obvious to combine the two to reach your invention. And that's where most of the argument comes into play in the patent office. If it's anticipated, typically it's anticipated. You can't really argue. You have to amend, unless the examiner just doesn't understand the invention.
Absolutely. Thank you, David. All right, I'm going to move on to our next topic. So the researcher has disclosed their invention to my office. We've shared the disclosure with David's firm. We've made a threshold determination that we think this is potentially patentable. So now we start with the drafting of the application. So David, I think you touched on this already in terms of the information needed from the faculty member or the student to draft the application. You mentioned a very detailed description in order for someone to be able to theoretically practice the invention, and all of the names of the inventors. Now, inventorship is a very specific legal determination under patent law. So can you speak about that a little bit and what qualifies someone as being an inventor?
The rule of thumb that I use is anyone who has contributed to the conception of the invention and no one who has not contributed to the conception of the invention. If it's a close call, I think you should be consulting with a patent attorney in any event, but if it's a close call, it might be better to err on the side of inclusion. Excluding people where it's a close call, although, well, let me step back. If you intentionally misrepresent inventorship and it becomes an issue in litigation or down the road, it's grounds for invalidation of the patent. So it's an important factor. You need to name the inventors and not name non-inventors. But where it tends to come up is where you have not named an inventor who should have been named, and that's where there's challenges made. So it's important, in my mind, to make sure that you don't exclude people that should be included. And again, it's a difficult determination under certain circumstances, and that's why where it's in that gray area, definitely should have an attorney, a patent attorney looking at it. And just to step back for a second, Dana. I realize we covered some of the topics of the disclosure, but I just wanted to emphasize a point, which is the requirement again to we're looking for a disclosure that's sufficient to enable a person. The bare minimum is that it should be sufficient to enable a person of ordinary skill in the art to practice the invention without undue experimentation. Some amount of experimentation is permitted. What that is hard to say. So it's better ultimately to disclose more in terms, you don't want to have to rely on experimentation if it comes down to it, to enable others to use it. And ultimately, if the patent's ever litigated, it's not going to be litigated by people that are as experienced as you are as an inventor. It's going to be litigated, and I'm not saying litigated, but it's going to be judged. There's probably going to be either a judge or a jury or both that don't necessarily understand much about your technology. So I find it a good practice to try to write to a lower level of audience than the person of ordinary skill in the art, although you're permitted to write to the level of ordinary skill in the art. So that's just something I wanted to add. Thanks, Amy.
All good things to think about. Thanks, David. And I'll just go back a little bit, talking about inventorship. And David mentioned the rule of thumb is someone that's contributed to the conception of the invention. Scenarios I've seen come up in my role at FAU over the years is sometimes a faculty member will want to reward a student who has worked in their lab, but they really didn't contribute intellectually to the invention. So in that case, I say that's a no. You should not name that student as the inventor. Or a lot of times you will have postdocs, research assistants, other faculty members that are working in your lab and performing tests, gathering data, all at your direction. But again, they're not coming up with intellectual contributions to what the invention is. So again, that would probably be a situation where I would say you should not name those people as inventors because they have not intellectually contributed. And this determination of inventorship, I'll also mention, is determined on a claim-by-claim basis. So as an inventor, you don't need to contribute to every single part of the invention, but if you contributed to the conception of at least one of the claims in the patent application, then you should be named as an inventor. So I just wanted to emphasize that before we moved on. Okay.
That's a good point. If I could jump in for a second, Dana. Again, we don't know the level of understanding of all of our audience. So the claims are numbered paragraphs at the end of a patent application or patent that do define the invention. Everything prior to it is the specification or background that help to understand the claims, but it's the claims that define the scope of the invention. So different claims could have different inventorship, as Dana said.
Thanks for clarifying that, David. All right, so when do we decide if we want to file a utility application, and what are the other types of patent applications? We know a utility application is one type, but there are different types of patent applications. So could you just briefly describe what those are and when they might be applicable?
There are three in the U.S. There are three types of patents, patent applications. So there's a plant patent, an application that relates to plants, and fairly uncommon. The second type is a design application or a design patent. They're pretty common. They're actually Typically in the past, people thought that their value was limited, but there's examples of design patents that are worth multiple millions, if not billions, in litigation. The design patents are directed to the ornamentality of an invention as opposed to the utility. And then the third type of patent would be a utility patent, which is what we discussed earlier, that relates to the functionality or utility as opposed to the appearance or ornamentality, which is the design. There's two types of utility applications that we file. One is in the US, and the one type is a provisional application. A provisional application replaces what inventors used to do, which was write down their invention on a piece of paper and mail it to themselves in a sealed envelope and not open the envelope so that they can later prove the date of invention. So in a sense, you are describing your invention. It's being filed in the patent office. It's not really being examined. They just make sure that there are parts there, and it just sits there for up to a year. And if you don't follow up within that year with either converting the provisional to a non-provisional or filing a provisional, non-provisional claiming priority to the provisional, then it just goes abandoned and you lose the earlier filing date. So one of the purposes of the provisional is, as I said, just to establish an early filing date. If you're still developing the invention, this is one way of allowing you to further develop the invention during the year and then add the additional data and file the non-provisional a year later. One of the great benefits of provisionals that I believe is taken advantage of by, for example, probably every pharmaceutical company is you file a provisional and it does not count towards your ultimate patent term. A patent term is 20 years from your filing date, but a provisional filing date does not count. So that first year doesn't count towards your patent term. So in the case of pharmaceutical, where the last couple years of patent coverage could be worth billions, it's worth filing a provisional, even though it's a complete invention, and then file a non-provisional 1 year later. One additional type of patent application to mention that you'll be encountering is an international patent application or a PCT application under the Patent Cooperation Treaty. It can't, in and of itself, become a patent, but it leads to patents. There needs to be additional work. So there's an international phase of this international application of the PCT. We file it, it gets examined, and then ultimately, if you're ready to proceed about 18 months later, you then enter all the national phases in the various countries.
All right, thank you for that overview, David. We did get a question from the audience while you were speaking, and it has to do with patentable subject matter and or how to protect a certain type of innovation. So this person asked, what about research products that are not necessarily innovative, but they are valuable to other researchers? So he or she gave examples that would be large collections of clinical samples, like a tissue bank, or perhaps a big experimental data set that is useful for artificial intelligence and machine learning experts to test their new methods on. How should researchers that collect big tissue banks or data sets in the course of their work proceed in making the product available to other researchers, while also getting the recognition and or remuneration that we deserve? Okay, so they're asking basically about protecting non-traditional sources of IP. So they mentioned specifically tissue banks and large data sets. So David, can you speak at all to how someone first might protect each of those things, and what other considerations there might be in terms of those types of subject matter?
Sure, I'll give it a shot. So, I mean, there are multiple methods of protecting intellectual property, which I touched on earlier. So in this case, in these cases, it would most likely be something you would attempt to protect. If you can't protect it through patent rights, then the alternatives might be trade secret, which I touched upon, or some sort of a contractual basis where you're only disclosing, which kind of ties into trade secret. So let me step back. I wouldn't assume necessarily that it's not patentable. It could be difficult to patent, but consulting with your tech transfer office and consulting with an attorney patent attorney. There may be some creative way of claiming it that you can actually protect what you don't think is protectable. But assuming you can't protect it, or you don't want to just rely on that one basis, because I don't think we've mentioned earlier, some of these things are complementary, and it's like belt and suspenders. You can protect yourselves in different ways at the same time. So one other way of protecting these types of information collections would be through some sort of a controlled access, or which touches upon trade secret, which is something that you try to keep to keep secret, so the public cannot use it without confidential access that you grant. So in terms of these things, I guess material transfer agreements, these types of agreements where if someone wants to use your database or information, they have to agree to acknowledge it and keep it confidential.
All right, thanks for fielding that question. All right, I will go back to the topic we were discussing before. So you described the different types of patent applications that are available. So the most common one we typically handle at my office is a utility patent application. So once the application has been drafted, what are the next main steps in the patent application process? What happens from there?
Well, we file the application in the patent office, and as part of the application, we should be disclosing information. As I had mentioned earlier, there's an obligation on the part of the inventors, the attorneys that are representing the inventors, and the owner of the application, or the applicant. ASNE, in this case, Florida Atlantic University, all have a duty, an ongoing duty during the pendency of a patent application to disclose to the patent office information material to the examination of the application. So if you are aware or you become aware of publications or other information that you would think an examiner would want to know about to decide if you have a legitimate patent, we have an obligation to disclose that to the patent office, and we do that through what's called an information disclosure statement, or IDS. So the application's filed. Hopefully, we don't have a duty to go searching for information, but if we're aware of it, we file an IDS. Patent office typically takes quite a while to examine the application. I'm going to want to probably try to show you a slide to give you a sense of that. When the patent office picks it up, which could be a year to 2 years later, the examiner decides whether there's any deficiencies or objections, rejections that he or she wants to make to anything about your application. It could be the specification of the application, it could be the claims, could be both, and then provide you with what we call an office action, which describes these things. You'll then have up to 6 months to respond to the office action, typically in writing. There are opportunities to arrange what's called an interview with the examiner, which is a video or personal, in-person or telephone conference with the examiner to discuss the invention, to discuss the application. But ultimately, there's going to be a written response, which we generally, if we're changing anything about the application, we call an amendment. So in response to these office actions, we file an amendment within 6 months, typically. Then the examiner will look at the amendment, and if they decide that it's allowable, they'll allow the application. If they don't, what can happen, but doesn't have to happen that quickly, is you get what's called a final rejection. Final rejection is the way the patent office limits the amount of times you can argue with them for the same amount of money. So if there are rules that apply to limit when they can say it's final or when they can't. And if it's a final rejection, the examiner does not have to permit you to amend further. And if you want to continue to argue or continue to amend, you have to file either a continuing application of some sort, or what we call an RC, which is a request for continued examination, which costs about the same or more than filing an application in terms of the USPTO fees. So once you do that, it restarts examination and you get more bites of the apple, as we say. If At some point, the application is allowed. The examiner will send a notice of allowance, which will describe, usually describes why the examiner thinks the claims are allowable, what claims are allowable, and will set a date that you have to pay what's called the issue fee. And if the issue fee is paid on time, the patent will then grant, publish about 2 to 3 months later.
Okay, great. A question I get in my office a lot, I think a lot of researchers aren't necessarily aware of how long the patent process takes from start to finish and each stage of the process. So if you could speak a little bit to that and inform our audience if there are any ways for them to check on the status of a pending application. They can always contact my office and I can contact you, but is there any way for them to look up these things on their own?
Okay, I'll start with the second question first, and then try to show a slide illustrating the amount of time. So there's something called the PAIR, P-A-I-R system at the USPTO. So if you go to uspto.gov, I'm not sure what the link is, but it's called PAIR, P-A-I-R. It is available. It's called public PAIR. There's two types of PAIR. One is private, one is public. The private is limited to the attorneys of record. Public PAIR is for the public in general, so other people. The only time, as well as yourself, the only time public PAIR will have access to the application, or you're looking for an application, the only time you'll be able to see that is after it has been published. So, and there's some minor, if it's in a chain that something else was published, it's also possible. But if it's not published, or it's not in a chain that's been published, you're not going to be able to see it yourself. And yes, you'd have to go through your representative, your attorney, to find out what the status is. And in terms of what expectations are, in terms of when the PTO will examine, I am going to share. Oh, I can't share the screen while it says while I'm in this mode. So
I think I had to stop sharing. I think you should be able to now.
And hopefully I don't show you a picture of my dog or something. So you should be seeing a bar, a line chart or a graph. Is that what you're saying? Yeah, good. Okay, so what that is the measured amount of time over the last year or two at the patent office, from the time of filing to the first office action on the merits, which means an office action that relates to the actual rejections and not some trivial background type thing, like it's a restriction requirement or something. So the time from when you file until you get a substantive office action averages for the last, going back to January 20 up until last month, January 2022, sorry. So the different colored lines represent what are called different technology centers. And the reason I wanted to show you this is because it's different for different technologies. For example, the brown, which is like the second from the bottom, if you look to the y-axis, is fairly low down on the chart, although it's really creeped up a lot of late. That's chemical technology and the like. So that's lower down. I'm not sure the exact number of internet inventions and business methods and the things that are not always necessarily, the things that are more controversial, they have that relate to computer technology, like they tend to be on the higher end. So the range they're showing here is anywhere from looks like 12 months to 19 months. And these are averages for each of those art units. So it varies widely. And I think in the technologies that I mentioned that relate to computer science and the like, it tends to be more like 2 to 3 years before you get a first office action, despite what this shows. Maybe this is an average, but it's an average. So it's not always the case.
Yeah, no, this is very informative. I think it's very helpful for people to keep in mind how long the process actually takes. But that's not to say that they can't be doing other things in the meantime while their patent application is pending. You mentioned they can continue doing further research and development. Once the patent application is filed, they're free to present, publish, publicly discuss their invention without any concern of jeopardizing their patent rights at that point. So there are things that we can do while the patent application is pending. My office also works with you to help commercialize your innovation, which was the subject of our previous webinar. So there are things that are happening. It's not just you're sitting and waiting for years. Other things are happening in the background. David, are you able to stop sharing?
It seems like I'm not. So if you can undo what I'm doing, that would be great.
It's not allowing me. It says I cannot start screen share while the other participant is sharing. At the bottom of your screen, or possibly at the top, there should be an option to stop sharing. But if not, I'll just keep talking.
Yeah, I've got a screen view that I'm not seeing anything at the bottom. So let me try some other screen views. Yeah, no luck here. So can we?
All right, we'll just keep going. Looking at your
Hold
lovely
on,
slide.
I think I might have found it. Sorry. It's
Okay.
actually in a toolbar at the top. So stop share. Okay, we're
There
back.
we go.
Sorry
We're
about
back.
that.
No problem. All right, I will go back to my screen now. All right. I know you described when we were talking about the different types of patent applications, you brought up PCT applications, how they're kind of considered international applications. So I just wanted us to distinguish between the utility patent application process that we just described and the process when you file a PCT application, the timing, the different phases. It's a little bit different. So I just want people to understand in case they're interested in possibly pursuing a patent in other countries.
Right. It's actually pretty complicated and there's a lot of options. Typically, it's when you encounter it differs typically, but it's not required that it be done in a different time frame. What I'm trying to get at is you can initially file a PCT application. You don't have to file in the US first. You can file, well, you have to get a license if you're a US inventor. So that's a foreign filing license if you're filing a PCT, but I think you file it through the PCT office in the USPTO, that's taken care of. But the more typical case is you're going to file an application in the US. And then within a year, within the 12 months of the initial filing, if you want to file and claim the benefit of your first filing date, you have to file additional applications. So what's typically encountered through FAU is there's a provisional filing, and then as the year is coming to an end, and in fact, if it's got government support, then it's a 10-month deadline. We need to file we need to file a non-provisional and/or a PCT application within that year, or in the case, 10 months of where there's government support. And so the PCT is filed. It could be identical to what you filed in the US, or it could be different. They have different rules. They have different rules that apply as to how you're claiming things. So you may want to modify, your attorney may want to modify the PCT before it's filed to take advantage of rules that don't apply in the US. Then the application is filed. About 6 months after the application is filed, ideally, there's an international examination by an international examiner, and they then will, well, there's a search report, I should say. So a search report just lists references that are relevant and grades them by category. There'll be letters like X and A and U, I think U, that just signify that they, without giving you an argument, they will say that this reference alone defeats the novelty of claims X, 1 through 2. And this reference is in combination relevant to the obviousness of your invention in combination with other references, but they don't make the arguments. It's just a table that gives you those letters that define what it means. Then, several months later, there's something called preliminary examination report, written opinion from the international examining authority. Sorry. So that will then be like an office action in the U.S. and it will describe why it is the examiner does or does not think that your invention is patentable and claims as to each claim, and cite the references that were found in the search report. It's also possible that you'll get a positive initial examination in the written opinion, and so it'll be all favorable. Either way, it is a non-binding opinion on the subsequent examination in the various national offices. So you file the international application, there is an international search, there is an international examination, you have an opportunity to respond or not respond. And based on whether it's a positive result or non-positive result, there'll be some sort of publication that goes out to the public, that goes out to other offices, and usually it's actually the deadline is 30 months from your priority date. So if your initial filing was, in the U.S. and you filed your PCT within 12 months, then 18 months later, you need to decide whether you're filing any national phase or regional phase applications. National phase, for example, in Canada, national phase, for example, in Japan, regional phase in the European Patent Office for all of Europe at the same time. So you make those decisions about 18 months after the original filing of the PCT, unless the PCT was the first filing, in which case it's 30 months later. But one of the advantages of the PCT is that it is a time extension device. It doesn't become a patent itself, but it gives you more time to decide whether you want to invest a far greater amount of money in filing applications in all the countries that are members of the PCT, which is pretty much any country in the world, with the notable exceptions of Argentina and Taiwan. So you would have the opportunity by filing a PCT to delay the time to claim priority to your original filing date.
All right,
And, sorry.
Oh, no, that was great, David. I was going to cut you off there. I think that's a lot of information for folks to digest, but I think it gives them a good overview of the PCT application and how that could be beneficial for them, and how that process works. We're starting to run short on time, so I just want to make sure we get to everything. We already touched on patent prosecution previously. You gave us a great explanation of that, so I won't ask you anything further there. So I'm going to move on to patent issuance. So this is really the end goal with the patent application process, is to eventually obtain an issued patent from the U.S. Patent Office or internationally. So we talked about the timing. This whole process usually takes several years. We also mentioned the term of protection of an issued patent, that a utility patent, the term is typically 20 years from the earliest non-provisional filing date. So that is the time, as David described it, in which you have a limited monopoly to exclude others from making, using, offering to sell, selling, or importing your invention without your permission. So that gives everybody a sense of the timing and the term of protection that you have. David, you talked a little bit about cost when you were describing the PCT and how filing in a lot of different countries adds up. Can you give folks just kind of a rough estimate of how much it typically costs to obtain, say, a basic utility application in the US only, and then if they wanted to file in other countries exponentially, how would those costs increase?
It's a difficult question. So the PTO charges fees, and then you're going to have professional fees for your attorney. So typically, the PTO fees, whichever office you're paying, are going to be far less than your professional fees, at least for your initial filing, because you have to prepare an application, which is a labor-intensive effort, unless you deliver to your attorney a pretty close draft of what the application needs to be. So stepping back to the official fees, there are different fees depending on what your status is, of whether you're a large entity. Large entity is defined and it wouldn't obviously be you as the inventor, but if you have a duty to assign to a large entity is more than 500 employees in the US. That's the definition. There are different definitions in different countries. They get no discount. Small entities are companies that have up to 500 employees or nonprofit organizations such as FAU that get to pay usually 50% of the fee that a large entity would pay. There's even a further reduction for individuals and organizations that have very limited exposure to the U.S. patent system prior. I think they can't have more than 4 earlier patents applications filed, a utility patent. That's one requirement, and the other is this is one way of doing it. The other is that they only make their income is somewhere under the range of about 200,000 a year. There's a specific number that you have to look up, and you have to sign a certification. You end up getting your price reduced, your fees reduced even by another half. So it's a quarter of the normal fee. It's significant, but you do have to jump through several hoops to get there. In terms of, in general, if we're talking about an average complexity patent application of average length in a technology, in basically any technology, the range for what it will cost for an attorney to prepare an application and file the application and pay the fees is probably going to be somewhere in the range of $7,000 to $12,000 in total to prepare and file an application. And I'm not just talking about my firm, I'm talking about other firms I'm aware of. So you may find people that are solo practitioners that may be able to do the job for less, but it's going to be it's typically going to be in that range, and that's for average complexity. If the actual application is going to end up being more than about in the range of 10 to 15 pages, it gets more complicated. Obviously, there's more work involved. And as I said, for your inventors, if they're producing and they're participating in a way that's significant, it may keep your costs down, keep their costs down. So that would be for a U.S. filing. Then, if the typical cost of filing a PCT application, should you choose to do so, is going to be the filing fees and an attorney fee. It's going to be in the range of $3,000 to $6,000 for you to file a PCT, which, as I said, it buys you 18 months of further pendency. And one reason you would do that is because if you don't do that, then that means you have to go directly into the foreign countries if you want to claim priority. And at that point, for example, your fees could include translation fees. So if you're filing in Japan and it's a significantly long application, and they have their fees as well for claims, you could be looking at could be like in the $7,000 to $12,000 if it's even of a reasonable length. Certain countries are going to be more expensive that require translations on filing and other things. So it varies, but if you're talking about filing in 5 to 10 foreign countries and not just Canada, you're going to be looking at in the mid 5-figure range for filing applications. And then every country wants to get a payment. Almost every country, they're called annuities. So they're called annuities because every year they want to get paid a tax. It's essentially a tax on your application even before it becomes a patent. So there's a lot of fees and you have to keep up with it and you have to pay them every year. It's an expensive proposition. The US, on the other hand, you file the application, they don't charge you annuities. When your patent issues, they want what are called maintenance fees, which are not every year, but they're every 3.5 years roughly. There's 3 of them, and they go up quite a bit. So 3 years or 3 to 4 years after your patent issues, they want a payment, and then 7 years, and then 11 years, and that's it. They do that to try to clear the records of unused patents. So if you're not using it, you're not going to pay the fee. Makes sense.
David, thank you for that summary. I know there's a lot of different fees, a lot of different things to consider, and it adds up very quickly. We're almost out of time. So I just wanted to emphasize that for those of you that are FAU personnel, all of these costs that David just spoke about are covered by my office. So if you disclose your innovation to my office and work with us through the university, my office covers all of the legal expenses related to protecting your research through patents, copyrights, trademarks, et cetera. So that is one thing, at least, that you do not have to worry about working through my office at FAU. All right, well, we have a couple minutes left for questions. So last chance, if anybody wants to submit a question, please feel free to do so now. Unfortunately, we didn't have time to get to our last topic, but perhaps that'll be the subject of a separate webinar in the future. So I'll just wrap up by saying thank you very much to David for being here with us today and answering all of these questions. I think they're very helpful for the researchers to get a better understanding of what a patent is, how it's beneficial to them, what the process looks like. All good things for them to start thinking about during their research here at FAU. The recording of this webinar will be available shortly after today. Once it is edited, we'll post it up on my office's website. So if anybody wants to view it or share it after the fact, please go to the Office of Technology Development website and you should be able to find it there in a few days. David, any parting words from you?
Just my appreciation for hosting this. Thank you for having me, and I'm happy to answer further questions offline if anybody has any.
All right, yeah. Both of our contact information is there, so please feel free to reach out to us if you want to learn more about anything we discussed today. So thank you all very much for attending and hope you have a great rest of your day.